Module 3. Topic: the liability that you as a server can be accountable for. Module objectives. After completing this module, you will understand the following. Number 1, dram shop lawsuits. Number 2, the potential legal consequences of overservice. Number 3, what you can be sued for. Number 4, civil lawsuits for serving a minor. Number 5, who can sue you. Number 6, damages you would have to pay. Number 7, criminal liability. Number 8, how to protect yourself from dram shop lawsuit. Number 9, using a logbook. And number 10, alcohol serving policy. There are 3 parties in a dram shop lawsuit. You got the first party is a drinking party, that is the customer. The second party is the serving party, that is you and the establishment. The third party is the person outside of the alcohol transaction, the person who was injured, the property damage. Here's the way it breaks down. Mrs. Jones comes into your bar. She sits down and she's serving her some Merlots. And after a while, she said some Merlots. She can't quite get the word out of her mouth. It comes out something like, lots of Merlot, please. Like, hey, drunk lady, you're done. Dang that. She's like, excuse me, I'll tell you when I'm done drinking. I'm going someplace else to appreciate my business. And she gets up and leaves, and you do nothing to stop her. Now, you might make a comment to her, like, are you okay to drive? And Mrs. Jones says to you, yep, I'm fine, and she heads out the door. Well, she's driving around the road, and here comes Mr. Smith, and she crashes into Mr. Smith's car and hurts him really bad. Here's what can and probably will happen. Mr. Smith will sue Mrs. Jones for hitting her. Then Mr. Smith can sue you and your establishment where you're serving alcohol for over-serving Mrs. Jones. Mrs. Jones is also hurt in the crash. Mrs. Jones can sue you for her damages. Mr. Smith can sue you for his damages, and sometimes even Mrs. Jones and Mr. Smith's insurance companies can sue you for their damages, and Mr. Smith will likely win. While Mrs. Jones will have a harder time in winning than Mr. Smith, there is still a good chance she can win too. You've been hired to bartend at a cash bar at a private residence, and you overserve a person alcohol, and that person has a car crash. The consequences are exactly the same as Mrs. Jones from the earlier example. These alcohol lawsuits are not new. They've been around for centuries. Texas's law for alcohol lawsuits is informally called the Dram Shop Statute. It provides the exclusive legal remedy against a provider or sellers of alcohol who provide a beverage to a person 18 years of age or older. Almost all lawsuits against serving parties and establishments come under the Dram Shop Statute. The main exception to this is where the person served was under 18 years of age. We call these lawsuits Dram Shop lawsuits. Here's a quick trip to law school about the Dram Shop Statute in Texas. Number 1, the Dram Shop Statute for server and establishment alcohol liability comes from Texas's Alcohol Beverage Code 202. It states, alcohol providers may be civilly liable under the statute if at the time the alcohol was provided, it was apparent to the provider, and the recipient was obviously intoxicated to the extent that the recipient presented a clear danger to himself or herself and others. Let's break down the statute. Who is an alcohol provider? An alcohol provider is a person who sells or serves alcoholic beverages under authority of a license or permit issued by the Alcoholic Beverage Commission, or who otherwise sells alcoholic beverages to an individual. What does apparent to the provider mean? It means that as long as intoxication is visible, evident, or easily observed, it counts. It does not require the provider to have actually witnessed intoxicated conduct. What this means is that servers need to pay attention because the law is whether or not the server could have seen that the customer was intoxicated. What does obviously intoxicated mean? Was the customer slurring her speech? Were her eyes red? Did she stumble or sway? How many drinks did you serve her and over how long? It can even be based off of strange evidence. For example, a Texas judge in 2001 found that an alcohol bill of $108, Flaming Dr. Peppers, Kamikazes, and beer served to 2 people was enough evidence to satisfy the obviously intoxicated requirement. What about clear danger to himself, herself, and to others? It is practically presumed that a person who is obviously intoxicated is going to pose a danger to himself, herself, and to others if there is any chance they will be driving. In other words, if they're obviously intoxicated, assume that they are a clear danger to himself, herself, and to others. Also, the plaintiff must prove that the intoxication of the recipient of the alcoholic beverage was a proximate cause of the damages for which recovery is sought. Texas Alcoholic Beverage Code 202, what does this mean? It means the provider is not liable for damages caused by conduct other than providing, selling, or serving alcohol to an obviously intoxicated person. For instance, if a customer walks into your establishment already obviously intoxicated and you refuse to serve that customer, you will not be civilly held liable, even if you don't call a cab because you never provided, sold, or served that customer any alcohol. It further means that it has to be the intoxication of the recipient. For example, in 1990, a convenience store sold beer to an obviously intoxicated person. That person then shared the beer with his friend who was driving and afterwards had a traffic accident. The convenience store was not liable because they didn't provide the alcohol to the driver. Rather, they only provided alcohol to the driver's friend. Who can sue you under the dram shop statute? Number 1, the obviously intoxicated person that you served, and number 2, any third party who was hurt as a result of the obviously intoxicated person's conduct. Dram shop lawsuit. If you overserve someone alcohol, you can be held directly accountable for their actions. So don't overserve. Problem is, it will happen. There are a lot of different variables which can make it difficult for you, a server involved in the service of alcohol, to protect yourself from a potential dram shop lawsuit. For example, the customer began consuming alcohol at home. They have a flask in their pocket. They're mixing the drugs. They have a low tolerance, etc. But what are the potential legal consequences of overserving? There are 3: licensing consequences, civil consequences, and criminal consequences. You have licensing consequences. You lose your livelihood. Your employer loses his license also. You have civil consequences. You lose your home, your life savings, and whatever else you've accumulated. The licensing consequences are relatively straightforward. If you're caught, you lose your license. The civil consequences require a more in-depth treatment. When looking at the civil consequences, there are a few specific questions to ask. What can I be sued for? Who can sue me? What types of damages will I have to pay? What can I be sued for? The dram shop statute for server and establishment's alcohol liability comes from Texas Alcoholic Beverage Code 202. It states, alcohol providers may be civilly liable under the statute if at the time the alcohol was provided, it was apparent to the provider that the recipient was obviously intoxicated to the extent that the recipient presented a clear danger to himself or herself and to others. Important things to remember. Number 1, you can overserve someone even if you have no evidence they have had anything to drink beforehand. The main question is whether they appear obviously intoxicated.
I really gotta go to the bathroom, so I'm gonna be right back, okay?
All right. Yeah, you gonna take a drink with you?
All right, later. Oh, we'll leave that right there.
You might want to leave some breadcrumbs so you can find your way back.
Hey, who is that guy?
Number 2, as long as the intoxication was visible, evident, or easily observed, it counts. It does not require the provider to have actually witnessed intoxicated conduct. What this means is that the servers need to pay attention because the law is whether or not the customer was obviously intoxicated and not whether the server actually saw that the customer was obviously intoxicated. What if I serve a minor? Serving any liquor to a minor can lead to civil liability for any foreseeable act that the minor does. You can be liable to the minor if the minor hurts himself or herself, but you can protect yourself from liability if you thoroughly check the buyer's identification. Texas Alcoholic Beverage Code 106.03b.